And we need to make sure we take firm, decisive action to deal with illegal migration. I'm open-minded to looking at this bill to see if it delivers that. But does she agree with me when I try to intervene on the Home Secretary? The point is this. The number of people in the UK who've lost their asylum claims, but yet they are still in the UK. What are we going to do, and what is the government plan to ensure that those people are removed? Because that is a deterrent. And I haven't been given the numbers of how many of those who've lost all their claims have been removed in the last year, for the last 2 years, or the last 3 years. Because if we want deterrent, we need to look at that as well as this.
Vet Cooper.
So I totally agree with the honourable member. And that is why I hope there should be cross-party support for a plan to have a major new returns unit to actually turn that round. You've got 40,000 people who are here, who've had their claim rejected, who should be being returned, and they're not being. A 50% drop in returns under the Conservatives over 13 years of the Conservatives. Actually, a further 17,000 who've just disappeared into the system altogether, where there should be proper enforcement as well. But the government's not taking action on any of those things. There's no grip in the system. So actually, Labour would do that. We would set up a new major returns unit with 1,000 staff to make sure that we have proper enforcement in place. And the combination of that and the caseworkers will save the taxpayer £2 billion as well. But this treaty and the legislation before us, let's progress first. The treaty and the law before us, we've got the treaty says that numbers are limited by Rwandan capacity. The number of vulnerable refugees sent here, of course, is not limited. The treaty says Rwanda can terminate the deal at any time, doesn't have to take anybody. The treaty also says the UK will fund the support of asylum seekers and people granted refugee status for 5 years. That includes accommodation and 3 meals a day for 5 years. Well, that's more than here in the UK. It says that people can't be sent anywhere else but can be sent back to the UK, and the Immigration Minister, well, at least one of them, has confirmed that if someone commits a terrible crime in Rwanda, actually the Rwandan justice system doesn't have to deal with them. They can just send those criminals back to the UK. So you couldn't make it up. You've got trafficking and torture victims and Afghans who help our armed forces and have fled the Taliban sent to Rwanda, but convicted criminals sent back here. The law before us is a total mess, which is why all sides of the Conservative Party don't like it, even though most of them will still vote for it because they are in such a mess. Some of them want to stop all court challenges. Actually, I think probably some of them want to stop all courts because they've long ripped up being the party of law and order or the rule of law. Some of them want the UK to pull out of the ECHR, no matter the consequences for the Good Friday Agreement, the Windsor Agreement, the prospect of any future security or return agreements with other countries. And then this really astonishing scene of the British Prime Minister claiming that somehow it's the Rwandan government's commitment to the ECHR is the reason why he can't possibly breach it, that they are keeping the British Prime Minister on the straight and narrow, even though it's the Rwandan government who was found by the British Supreme Court to be in breach of international law. So this is kind of through the looking glass now. Does the Rwandan government really suddenly care about the European Convention on Human Rights, or did the Prime Minister ask them to say that they wanted the European Convention on Human Rights to be complied with because he was too weak to tell his backbenchers that actually he thinks our great country should abide by international laws that we helped write and that we currently urge everyone else to follow? I will give way to the honourable member.
We're grateful to the Shadow Home Secretary for giving way. She will understand the passion and anger that many of our constituents feel. In my own Bournemouth West constituency, we have 4 hotels full of people waiting for their asylum determination. They want this sorted out. The government has come forward with a plan. She is eloquently explaining her reservations about that plan and committing to cancel it. She is also explaining what she would do if she were charged with responsibility for this policy in the Home Office. Can I ask her, in the 12 months we have until the country has to go to face a general election, what is the timeline that the Right Honourable Lady would put on ending the boats if her policy was enacted? And will she, from that dispatch box today, give that date to the British people.
Well, I think the honourable member is just highlighting, actually, the failure of his front bench. All of us should want to stop these dangerous boat crossings. They are undermining border security and they are putting lives at risk. We should be seeking to smash the criminal gangs. We should be seeking to strengthen our border security. We should be seeking to return people who have no right to be here. We should be seeking to fix the chaos in the asylum system, because most people want to see both strong border security and also a fair and effective, properly controlled and managed asylum system, which we haven't got at the moment. That means clearing the backlog. It means setting up a new returns unit. It means seeking to work with France, with Albania, where we agree that actually we agree with the government on this. We support the work the government's done, but actually it should be going much further. It should be much further, the work with France, with Albania and with other countries as well. So we have that European cooperation in place. And all of us should be seeking to do that instead of the total chaos that we've got now on a gimmick that isn't about getting a grip. And the problem as well is, I will make some progress and then I will give way to the honourable member. The problem is that even if it stands, this law risks breaking international law, and that actually makes it harder to get further returns agreements and also to get further security cooperation that we need with our nearest neighbours. It's also why for the One Nation group to support this puts them in a pretty impossible position as well. The bill says in clause 1.5, a safe country is a country to which persons may be removed in compliance with international law. In clause 2.1, it says decision makers must treat Rwanda as safe, even if it isn't. So even if Rwanda does what it did over the Israel-Rwanda deal and breaches international law and does send people back for refoulement, even if Rwanda introduces new policies to send people abroad, even if there is a coup in Rwanda, even if Rwanda fails to stop organised gangs moving people to the border, even if asylum seekers are shot at in Rwanda, all things that the Supreme Court found had happened in the past. Even if the treaty is designed in good faith, if it fails, the government is still saying that British courts cannot consider the facts. I will give way to the honourable member. Oh, I did promise to give way to the other honourable member. I will come back to him in a second. I'll give way to the honourable member.
Fundamental difference in the government deeming Rwanda safe to what the Labour government did in 2004 in deeming a whole list of countries safe in precisely the same way, in precisely the same legislative technique.
Yeah, well, he knows that that's actually not the case, because what the government has done is to both deem and to remove any capacity for the courts to consider the facts. And it shows how absurd that even the government figures this is. A second. The Home Office's own legal guidance, published yesterday, quotes legal judgments, and it says, the court should not shrink from applying the fiction created by the deeming provision. And then it says, the statute says that you must imagine a state of affairs. It does not say, having done so, you must cause or permit your imagination to boggle when it comes to the corollaries. Well, the mind does indeed boggle. And here is the problem actually for the Foreign Secretary and for the One Nation group, because even as it stands, the government is effectively admitting that it is creating legal fictions, and it is saying that rather than following the facts, the courts will actually have to follow those fictions instead, and for the sake of a tiny scheme that costs not just 300 million, but possibly 400 million, and sets a precedent too. I will give way to the honourable member, and then I will come back, because I did say I would give way to the honourable member.
Lady for giving way. There are really 2 points to correct her narrative about what Labour would do, which the government is not doing. The first is which the government is already doing much of what she lists, and I can attest to that, having obviously in various different capacities having funded that. But also, she misses the point, as my honourable friend, the member for Gloucester, made a moment ago, that we are dealing in this instance with the consequences of large numbers of people coming to this country, not with the cause of it. That Rwanda seeks to address the incentives that are driving this illegal trade. It's only by getting Rwanda to work that we change the calculus, both for the people who are making this crossing, but also the people who are expediting that, i.e. the criminal gangs. Does she not recognise that that is why this scheme is so important?
Order. Before I call the Right Honourable Lady, could I just stress that when people make interventions, not only should they be fairly short, but after having done so, it is important to stay for the rest of the speech. Some people have been sort of wandering out, having made an intervention. So anyone who's thinking of making an intervention, please do bear in mind you have to stay then for the entirety of the speech. Yvette Cooper.
Well, just say to the honourable member that the problem for him is that he has got a scheme that's likely to be costing now £400 million, that is only likely to cover less than 1% and perhaps even 0.1% of the people arriving in this country. And that's why the Permanent Secretary has said there's no evidence of a deterrent. What we need is the practical measures to actually take action, to go after the criminal gangs, to work with our neighbours. And when he says that the government is doing this already, how come there's been a drop of 30% in the number of people convicted for people smuggling? If they are really going after the criminal gangs at a time when we know that the people smuggling across the Channel has rocketed, how come convictions for people smuggling have plummeted by 30%? And that is the evidence that the government is actually failing to do the basics to tackle those practical things. I will give way.
I'm grateful to her for giving way. She's making a really powerful case that seeking to legislate by assertion that Rwanda is safe is as dangerous as it is ridiculous. But does she agree that those who claim that this is about parliamentary sovereignty and that's why this sinister attack is justified are wrong, because Parliament can only be meaningfully sovereign within a functioning legal and constitutional system, which this bill totally undermines? Without the courts being able to interpret law, then the legal system doesn't work and it undermines this place as well.
So we do have a sort of constitutional roles for Parliament, for the courts. Actually, it is right for Parliament to respond to court judgments, to respond, to adapt, to change policy. But what this bill is doing instead is actually putting at risk the international law, the compliance with international law that we actually need in place in order to be able to actually make further agreements instead. And the problem in the end, I actually don't think in the end all of this is about Rwanda. I think it is about the deep divides in the Conservative Party. It's about their chaos. It's about the Prime Minister's inability to show leadership. It's about the fact that they just want to tear lumps out of each other, and they are creating chaos while they are letting the country down. The former Immigration Minister has said that what the government is now aiming for is just 1 or 2 symbolic flights off before the next election with a handful of illegal migrants on them. That is not the same as stopping boats. That is not the same as strengthening border security or fixing the asylum chaos. I will give way because I know the honourable member likes to think of himself as the leader of the common sense Conservatives group.
The Right Honourable Lady is right. I am the very personification of common sense, as she's just acknowledged. So the real divide here is between those people on that side of the chamber, very largely, who believe that international law trumps the supremacy of this place, and those who believe that the reason this place is supreme is because our legitimacy is derived from the people. Only a polity can make law. Only a polity can make law for that reason. And so international treaties matter, but they don't matter as much when it comes to this kind of legislation as the people expressing their will through those they elect to speak for them.
Well, I would say to the honourable member that it's actually that we are discussing this legislation not actually because of the European Court, but because of a decision by a British court, by the Supreme Court. and made a decision based on British laws as well. So I know that there are members on the backbenches who actually want to make everything about the European courts, and that actually is the heart of their dilemma. They do want to get rid of the ACHR. The Foreign Secretary, the Home Secretary and the Prime Minister have all said they don't and they won't. And that is at the heart of their divides and their chaos. This is what actually their row is all about. It's not actually about having a workable solution to the serious problem of our border security being undermined, of dangerous boat crossings that are putting lives at risk, of criminal gangs whose profits have soared as a result of effectively being allowed to let rip along the Channel because the UK and France have failed to work together sufficiently to stop them. I'll give way to the honourable member, and then I'm going to have to conclude my remarks.
Thank you. I'd just like to quote Article 21 of the ECHR, which clearly she likes to support in so many ways. That the will of the people shall be the basis of the authority of government. I don't understand how the will of the British people is being expressed within the European Convention of Human Rights and through their courts. Perhaps she can explain.
So I would just say that his problem, I think, with his own front bench. His problem is with his own Home Secretary and his own Foreign Secretary and his own Prime Minister. That's his problem. He wants to make all of this about Europe rather than us having a proper border security plan, having a proper plan to clear the backlog, a proper plan to fix the Tories' asylum chaos that they have created. Madam Deputy Speaker, instead of wasting taxpayers' money, instead of these performative rituals, instead of all the deeming and the boggling and the scheming, what we should be trying to do is build cross-party consensus on what really needs. They can't even build consensus within their own party. So I do accept this is particularly hard for them at the moment. But we should be trying to build a cross-party consensus on what really needs to be done to stop the boat crossings that are undermining border security and putting lives at risk, strengthening border security, smashing the criminal gangs that have spread their tentacles, going after the supply chains instead of ignoring these warehouses and lorry loads of boats crossing Europe unchallenged, getting real-time security information instead of carrying on with this ludicrous situation where we don't even know when suspected smuggler operatives are flying into our country, getting prosecutions and convictions for the smuggler gangs and their vile trade, clearing the backlog, not making it bigger, ending asylum hotel use, doing more of the things that we support, the cooperation with France, the deal with Albania, getting more workable deals in place and working together across this country and with other countries to stop dangerous boats, to smash the gangs, to strengthen our border security and ultimately to save lives. It is time to end all of this chaos. Time to ditch the gimmicks. Time for the government to get a grip.
The original question was that the bill be now read a second time, since when an amendment has been proposed as on the order paper. The question is that the amendment be made. It will be very obvious that there are a large number of honourable and right honourable members wishing to speak in this debate, and I would therefore ask that to start with, members speak for a maximum of 8 minutes. I won't put a time limit on, but I'm relying on colleagues to stick to that. Robert Jenrick.
Thank you, Madam Deputy Speaker. The decision to leave office is always a difficult one. The decision to disagree with the Prime Minister, someone who I want to support in good times and bad, is always a difficult one. But politicians are sent here to make difficult decisions. No one's forced to be a minister. And with high office comes responsibility. And no responsibility is greater than that to protect our borders and to secure us from untold damage as a result of mass illegal migration. We've made huge progress as a country over the last year as a result of the work that the former Home Secretary, the Prime Minister and I have done, and I wish my right honourable friend, the new Home Secretary and his ministers all the very best to take that work forwards. Our record stands amongst the best of any European country. We have, as my right honourable friend said, reduced the number of small boat arrivals to our country by a third. That compares to a third increase across Europe. And on Europe's southern border in Italy, an almost 100% increase. So the plan that the Prime Minister set out a year ago is working. It is the most comprehensive plan of any European country. And we've just heard from the opposition that they have no plan at all. They said that even if the Rwanda scheme was working, even if it was having the deterrent effect that we all want, they would still scrap it. Because ultimately, they don't believe in border security. And they cannot be trusted to protect our borders. But this problem isn't going away. This is going to be one of the defining issues of the 21st century. There are millions of people on the move, some fleeing climate change and persecution, others economic migrants, understandably in search of a better life. And it's a great compliment to our country that so many want to come here. But it isn't sustainable. I'll give way to the right honourable lady in a moment. It isn't sustainable. We have to secure our borders. And that means that all the good work that we've done over the course of the last year, the Albania deal, the asylum backlog work, the deals with Bulgaria and France and Italy and others, that isn't enough. We're not going to stop the boat purely on that work. You have to interject the strongest possible deterrent and the best deterrent, the only deterrent that we can use in the course of the next 12 months is the Rwanda deal. And that is why it is so critical that we get that up and running. I genuinely believe, having immersed myself in this issue for 14 months, that this is a good policy, that it can work, and that it will help our country to fight back against this great scourge. And in my job, I have seen the consequences of that every day. I've been with my honourable friend, the member for Dover, to meet her constituents, whose homes have been broken into and whose lives have been ruined by illegal migrants. I've been with my right honourable friend, the member for Bournemouth, and I've read about his constituent who was murdered by an asylum seeker who posed as a child and then killed somebody on the streets of Bournemouth. I've worked with almost every member in this House on their determinations to close asylum hotels. Even the greatest advocates for open borders change their minds when there's an asylum hotel in their constituents. Hypocrisy is all over this issue. This is why we've got to fix this problem. And that's why I say, when I said whatever it takes, I meant it. And I honestly believe that that is shared by all of us on this side of the House and many good colleagues on the other side as well. To do that, we have to make sure this policy works. And this is a good faith disagreement. There are good people on both sides of this House, and certainly within my party, who have disagreements about how we can make this policy work. But my point of view is this. When untold damage is being done to our country, when this issue will be with us for years and not decades to come, where if we do not operationalise this policy correctly, we will see the numbers rise, and we'll see them rise for many years to come. If, God forbid, there was a Labour government, there would be a decade of small boat arrivals. I want to stop that. There are two big flaws with this bill to my mind. The first one, as I've said to many people who've asked me, and I've said on the media, is that it doesn't address the question of individual claims. If I've learned anything in this job, it is this, that those seeking to frustrate their removal from our country will stop at nothing. The small boat chasing law firms and legal representatives will help them to find each and every way. Give them an inch, they'll take a mile. Even the best meant things that we've done as a country in recent years, like our world-leading modern slavery laws, are abused. 70% of those people who are seeking to remove put in a modern slavery claim at the 11th hour. I won't give way at the moment. Every time this is proven to be correct. So why would we not put into this bill a provision that says that those people cannot bring forward individual claims? I'll give way in a moment. And this means two things. Firstly, it means legal certainty, but secondly, it is for operational reasons. And I have not met anyone who really understands the operationalisation of this policy who does not believe it is critical to do this. Those advisers have told me time and again that this scheme will be seriously impeded. People will put in those claims. They will go to court. The upper-tier tribunal, which is already under pressure, will be overwhelmed. Our detention capacity, just a few thousand spaces, will be full. In a single week in August, 2,000 beds in our detention capacity could be filled. Those arrivals will go onto our streets. They'll abscond, as they always do, never to be seen again, and the scheme will be brought into quick disrepute. I don't want to see that happen. I'll give way to the Right Honourable Lady.
Thank you, Madam Deputy Speaker. Though I have to say I'm not a Right Honourable, but thank you, Madam Deputy Speaker. I think the Right Honourable will be giving way. He casts aspersions on Labour's approach to this. He is in the presence of two former immigration ministers, myself and the Right Honourable member for Birmingham Hodge Hill. And when my Right Honourable friend was the member in charge of this, there was one person being returned every 8 minutes at the end of the last Labour government. I know from my own caseload that people who have reached the end of the line are still dribbling around the system, either, as others have raised, they want to actually leave the country. What was his record after 14 months as an immigration minister in returns?
Tenfold increase in the pace of asylum decision-making. So we have absolutely transformed the decision-making system. We've massively increased the number of returns. The Honourable Lady is on rocky ground, I'm afraid, on this one, and 22,000 people have been returned. But the difference between this side of the House and hers is that we have the guts and the determination to fix this problem once and for all. And that means interjecting the strongest possible deterrent. And I worry what would happen. I worry for this country if there was a Labour government, because I think we would see a massive increase in the number of small boat arrivals. The people smugglers would be celebrating if there was a Labour government. That is why it is so important to us on this side of the House that we use. I won't give way. I won't give way with all due respect, because I only have a few minutes left. We need to use the time that we have left in government before the general election. Of course, I hope we win the next general election, but the public are watching us. They expect us to fix this problem. So why would we not put into this bill all of the strongest protections that are at our disposal? The second important thing that needs to change in this bill is this. It is inevitable, in light of the Supreme Court's judgment, that the Strasbourg Court will impose further Rule 39 interim measures. That is, after all, what bedevilled my right honourable friend, the member for Whittam's, flight a year or so ago. We have to stop that. It is a matter of sovereignty for our country that ministers, acting on the instructions of Parliament, do not allow those flights to be delayed. The provision in the bill today is sophistry. It is the express policy of the government that Rule 39 injunctions are binding, and to ignore them would be a breach of international law. So we are being asked to vote for a provision which it would be illegal to use. I do not want to be in the position that my right honourable friend, the member for Whittam, whose determination I do not doubt, was in. I don't want my right honourable friend, the Home Secretary, or my successors as Immigration Minister to be in that position. We as a House are giving them a hard deal. We're doing them a disservice if we allow the bill to continue in that way. They must have the full power of Parliament to ignore those Rule 39 injunctions and to get those flights in the air. There are other things I know that others will contribute, not least my honourable friend, the member for Stone, and the work that he's done, drawing out some of the other challenges with this bill. But I'll close with this. This is not a bad bill, but it is not the best bill. I want this bill to work. The test of this policy is not, is it the strongest bill we've done? It's not, is it a good compromise? It's, will it work? That is all the public care about. They don't care about Rwanda as a scheme. They care about stopping the boats. And we are sent here to do that for them. I will never elevate contested notions of international law over the interests of my constituents, over vital national interests, like national security, like border security. This bill could be so much better. Let's make it better. Let's make it work.
SNP spokesperson Alison Thewlis.
Thank you very much, Madam Deputy Speaker, and I move the reasoned amendment that stands in my name and that of my honourable friends. Madam Deputy Speaker, before I start, I just want to remark on the tragic news that emerged that an asylum seeker aboard the Bibi Stockholm was found dead this morning. Now, we don't know yet what the cause is, and we sympathise for that person and everybody who loved them. But what I do know is that our words and our policies in this place have consequences, and we should all reflect on that in the debate this afternoon. The UK's approach to migration, both legal and illegal, has been nothing short of chaotic. Poisonous rhetoric swirling around the plight of the world's most vulnerable at the Channel on a stormy night. I'd like to take a moment to reflect upon how the Tories have taken us to this parlous state. A former Home Secretary, the Honourable Member for Maidenhead, doubled down on Labour's hostile environment policy in a speech 11 long years ago. She promised to make life really difficult for those who came to our shores, to deport first and hear appeals later. The Immigration Act of 2014 and 2016 fostered a toxic culture of suspicion and disbelief in the Home Office, turning health staff, employers and landlords into border guards. This led to the Windrush scandal, to the TOEIC scandal, to lives fractured and still not put back together, to go-home vans and the highly skilled migrants 3225 scandal. People being forcibly removed despite having done nothing wrong. Directly to the dehumanisation found by the Brook House inquiry and to the rampant spread of COVID in scabies in Napier Barracks. They tightened up on the lorries, and then we had small boats, and the talk got ever tougher. The cry of stop the boats went out, the Nationality and Borders Act came and went, the boats kept coming. The Illegal Migration Act was passed, and oddly enough, this didn't prove to be much of a deterrent either. And today we have the Safety of Rwanda Asylum and Immigration Bill before us, which the Tories will claim will be the one to do it. Well, they think third time's the charm. Maybe it will, maybe it won't. I'm not terribly convinced. But the Permanent Secretary told a committee yesterday that there is no evidence that it will be a deterrent either. This is policy in a death spiral. Tougher and tougher and tougher. Turn the screw, threaten people with rendition flights to Rwanda. It won't work because nothing they have done before has worked. Why? Because it doesn't deal with the reason why people are coming here. Exactly. People will continue to put themselves in small boats because they feel there is no alternative. They come to reunite with family because of historic ties and because of the English language. It's all too easy to dehumanise, to speak of scourges and swarms and hordes, to speak of those who try and come here with no papers, those who somehow want to cheat the system and skip the queue. As the MP with the highest immigration caseload in Scotland, I see many of those people that ministers refer to at my surgeries week in, week out. I have to look them in the eye, as so many I know over the other side don't have to. I have 138 outstanding immigration cases if the Home Secretary would care to look at his inbox once in a while. So I will speak instead briefly about some of my constituents. I will call the first constituent Mohammed to protect his anonymity. He came here from Sudan and got refugee status. He applied for his wife to come, and after 9 months waiting for that application, he came to my surgery in March this year. In April, conflict broke out in Sudan. His wife's family fled to Egypt, but because her paperwork was in the closed visa application centre, she couldn't go. In May, I was told the case was allocated to a decision maker, but that the visa application centre in Khartoum was still closed. By October, the case was still with a decision maker, but there was no timescale for a decision, I was told. On Friday, Mohammed came to my advice surgery to show me pictures of the gunshot wound to his wife's leg and the video footage of those that had been killed in the same incident. So I asked members opposite, what would they do if it was their wife? There is no safe and legal route from Sudan, and the family reunion route is demonstrably not working in the face of an ongoing conflict. Yes. Would they advise her to sit tight and wait for a year and a half for the appropriate paperwork? Or should she try and cross international borders by whichever means she could to get to her husband and to safety in Glasgow? She's not wanting to skip the queue. She just wants the paperwork done by the Home Office. Or how about the constituents I will call Mr and Mrs R? They were unlucky enough to be visiting family in Afghanistan with their 5 children when it fell. With significant difficulty and scant assistance from UK officials, they were eventually able to return to Glasgow several months later. Yet they contact me regularly about the family members that they had had to leave behind. Despite the much-touted Afghan schemes, there is no route for them. Their relatives fled to Pakistan and had to leave everything behind, including their paperwork. The government of Pakistan is now sending people back to Afghanistan into the hands of the very Taliban they fled from. So I asked members opposite again, what would they advise Mr and Mrs R's family to do? Ask the Taliban for a passport? Wait for the Taliban to come and shut their door? Wait for the Pakistani government to arrest them? Or should they try another route? It's no accident that Afghans make up the greatest number of people in small boats. As Safe Passage have pointed out, in the first 9 months of this year, just 279 Afghans came through official routes. For every person arriving through the Afghan seams, 17 Afghans are crossing the channel in a small boat. And we've heard this week about how Arup is leaving those who served with our armed forces at risk of execution. I travelled recently with the Home Affairs Select Committee to hear more about what's happening in France and Belgium and their response to small boat crossings. The French Red Cross said that they have worked with young unaccompanied asylum seekers that they find who are trying to cross the channel to reach family members in the UK. They try to convince them of the merits of a family reunion application, but the backlog is so long, the casework is so slow, that they will inevitably wait for many months. Members in this place tend to forget that the channel isn't the beginning of somebody's journey, it's the end. It's the last leg. The channel holds little fear, given the dangerous journeys some have already made to be here. It could not be more tempting to know that they are so nearly to safety. If a humanitarian travel document existed, those same young people could avoid the perilous journey in a leaky rubber dinghy. They could get the same train or ferry as many millions of travellers do every year. They would not need to pay people smugglers at all. That would kill the business model at a stroke. It's the denial of this logical option that is placing people in danger. So what's the government offering instead? If you make that long and dangerous journey to our shores, your case will not be heard at all, and you may be sent to Rwanda. I will.
I thank the member for giving way, and she's making an excellent speech and bringing real humanity to this debate. Is she aware that those people in Calais that are trying to cross the channel are homeless, poor, desperate, and often victims of war and human rights abuses, and that walking away from international law and international conventions won't offer them any protection, won't offer protection for any other desperate people in the world, and will be a terrible message to the rest of the world that this country is turning its back on international law that we established in 1948.
He makes an excellent point, and this country is turning its back on its international obligations with this bill here today. It is a pathetic excuse for a policy, a foghorn signalling to the far right. It's too weak for some of the Home Secretary's colleagues, too harsh for a few exceptional others. For all the talk of full-fat versus semi-skimmed, it's more akin to milk which has gone stagnant and sour, utterly repellent to decent people, and best to be binned altogether for everybody's safety. For the SNP benches, it's an absolute abhorrence which undermines the UK's international obligations, the principles of human rights. It costs a fortune, and it's highly unlikely even to achieve its tawdry aims, and we should be lodging a prayer against the Rwanda Treaty. The legal experts that I've heard from are appalled at the implications of proceeding with a bill which, by the Home Secretary's own frontispiece to the bill, cannot be declared as compliant with the ECHR. The Home Secretary claims he respects the decisions of the Supreme Court, but he comes here today with the sole purpose of overturning them and to prevent them ruling on anything ever again. A government disapplying human rights when it suits them and instructing courts and public bodies to do likewise is a deeply troubling place. Liberty have stated that this bill will tie the hands of every court in the UK while also abandoning the UK's international commitments. Now, far be it from me to be concerned about the UK Constitution or standing in the world, but I note that the Law Society of Scotland have questioned the UK's rationale in disapplying a range of human rights agreements dating back 70 years and the global implications from this departure to the international rights order. ILPA, Justice and Freedom from Torture, say that this bill sends a devastating signal to the world about the UK's reliability as an international partner. It also begs the question of whether the breaking of international law is something the Rwandan government would actually accept. The Minister Vincent Biruta has reportedly said without lawful behaviour by the UK, Rwanda would not be able to continue with the Migration and Economic Development Partnership. It's beneath contempt for the UK government to say, on the one hand, we're presenting a treaty with Rwanda, marvel at how solid and unbreakable this treaty is, while telling us that they want to breach the Human Rights Convention, the Refugee Convention, the International Covenant on Rights, Civil and Political Rights of 1966, the United Nations Convention Against Torture and Other Cruel, Inhumane or Degrading Treatment or Punishment of 1984, the Council of Europe Convention on Action Against Trafficking in Human Rights done at Warsaw, 16th of May 2005, as well as customary international law, any other laws that might get in their way, including from the European Courts of Human Rights. International law is binding. No welching, no backseas, no keys up. They're supposed to adhere to it. That's why they signed up to it in the first place. It is abject nonsense. The Law Society of England and Wales go yet further. They state quite clearly that domestic legislation cannot immunise the government from the enforcement of international law. To claim it can is disingenuous. They also state that refusing to comply with an interim measure would be a clear and serious breach of international law. They accuse the UK government further of using law to manufacture a reality. Madam Deputy Speaker, it's the time of year we all indulge in some Christmas magic and imagine reindeers on the roof, but this UK Tory government has asked the entire legal system of the United Kingdom to engage in a far more dangerous pretence. The UK Supreme Court sought out the facts for itself, and upon that clear and substantial evidence found Rwanda to be unsafe. And this seems most likely why the government wants to ban courts from doing this again via this legislation. They speak of the risk of refoulement and sending people back into harm's way. And indeed, if Rwanda was safe, why would it be the case that they're also able to send asylum seekers to the UK as part of this deal? The Rwandan opposition leader, Victoire Ingabire Umuhoza, was sentenced to 15 years in jail for speaking out against the Rwandan government. Despite being released in 2018, he still, to this day, cannot exercise his political rights. His criticism of this deal has had to be done in the international media because he says the local media dared not give him a platform. If the Honourable Member could explain to me why Rwanda is safe, I'll certainly take his intervention.
The key thing about this whole debate is the tension that she's described, actually. Is she familiar with the rulings of Judge Denning, of Lord Hoffman, of Bingham, and more recently, of Reid, all of which directly contradict what she said about the balance between international law and laws passed by this Parliament. All of those very distinguished jurists say that the opposite of what she said. And does she at least acknowledge that truth?
I acknowledge that different lawyers will have different opinions, and the Law Society of England and Wales in their briefing says that the government is being disingenuous in what it is claiming here, and I will take their word for that, and my honourable friends, I'm sure, got a point on this too.
Picking up on the honourable gentleman's point, he cites various judges, but of course the most Supreme Court in the United Kingdom is the UK Supreme Court, and they were very clear in the Miller 1 case that while parliamentary sovereignty might mean that the law can be changed internally, this Parliament cannot legislate its way out of its international obligations. Now, does the Honourable Lady, my honourable friend, agree with me that no matter what various judges may have said at various times, it's a recent massive constitutional case of the UK Supreme Court we should look to on this issue?
She is absolutely correct, as her learned knowledge comes in many of these issues. And I think it is important that we reflect on these cases and what that actually means, rather than what members opposite wish that those cases mean. This legislation before us today declares Rwanda safe in all circumstances. In so doing, they are undermining the rule of law and the separation of powers, preventing the courts from establishing their own facts and driving a sleigh and a squad of reindeer through the principle of restraint. My torture metaphor ends here because, far from being Santa, the Home Secretary makes the Grinch look generous, and he truly does have a heart that is 2 sizes too small. This treaty creates new rules for Rwanda, but in reality nothing has changed in the weeks since the judgment. Lords Reid and Lloyd Jones said that intentions and aspirations do not necessarily correspond to reality. The question is whether they are achievable in practice. The Supreme Court found that Rwanda had thus failed to meet international obligation and is unlikely to meet additional ones. And there is no evidence that the long-term culture shift required is likely to happen quickly. Rwanda processed, I understand, only 228 decisions on asylum claims in 2020 and rejected claims from countries such as Afghanistan, Syria, Yemen, Iran and Eritrea. I don't want to get dragged into the merits or otherwise of Rwanda as a nation, as there is a far broader principle in play here. If we start to offload our international responsibilities to a third country, any third country, we're effectively surrendering our influence over what then happens next. This government themselves have become the people traffickers, sending human beings offshore against their will as if they were some kind of waste to be processed rather than human beings alike in dignity. There are also real concerns about the impact that this flagrant disregard for international cooperation could have on trade policy, on the Good Friday Agreement, the Windsor Framework. The implications of what is happening here today could be far-reaching and long-lasting across many aspects of all our lives. And then we move, Madam Deputy Speaker, to cost. And quite typical of the way this Tory government runs its business, there has been secrecy over the cost, with the Permanent Secretary finally forced to reveal yesterday the additional £100 million payment to Rwanda after the figures showed up in some International Monetary Fund paperwork. This on top of £140 million the previous year and £50 million years to come next year. This for a scheme that has thus far seen more Home Secretaries flown to Rwanda than asylum seekers. It will cost £169,000 per asylum seeker, significantly more than if they were processed in the UK and allowed to rebuild their lives here and to contribute to society as so many dearly wish to do. And we'd all know that the capacity of this deal makes it practically impossible. The estimated capacity of around 200 would mean the probability of being renditioned to Rwanda is 1 in 230. If the UK government were to remove everyone who did cross in a small boat last year, it would cost £7.7 billion. This would be an obscene use of public funds at any time, but particularly in a cost of living crisis. And then there's the ongoing problem, which the government is failing to address, of those people who have arrived and won't be removed, forever stuck in an immigration limbo with their cases deemed inadmissible. At what cost? Where will they stay? What will they do in the rest of their lives? The further danger of this bill is it will force people into even more risky behaviour. The Refugee Council have stated that almost everybody who does arrive in the UK does so after being intercepted by the UK Coast Guard, the RLNI or the Border Force, and many actively contact those agencies asking to be rescued. This bill makes it far less likely that they will do so. They will take more dangerous routes, they won't seek assistance, and the inevitable result of this is that many more will die in the Channel or in the back of refrigerated lorries as a result of this legislation. It will also leave people at the mercy of exploitative people traffickers. And the Home Affairs Select Committee have already found that, and I quote, "The fight against human trafficking is in practice no longer a priority for the UK government. This bill and the Illegal Migration Act which came before makes this worse." The treaty also says there's nothing to stop people leaving Rwanda once they're removed there, regardless of anything ministers may claim. And the BBC, in their visit to the Gashora refugee camp in Rwanda, found that those that had been removed there under other schemes didn't actually wish to stay either. They could say, and I quote, "Almost 2,000 people who have been relocated to the transit camp in Gashora since it was set up in 2019, none opted to stay in Rwanda when given the option, preferring instead to move to another country." So what do we have? We have the endless failed policies, we have the ramping up of tensions through rhetoric, we have ineffective legislation, we have overruling judges, we have abolishing the asylum system altogether, we have undermining human rights. It's like the TV series Years and Years on steroids. Madam Deputy Speaker, it doesn't have to be this way. Together for Refugees published this week a clear alternative to fixing this broken system and keeping people safe. Ministers couldn't be less interested. The response from the right wing to pillory Gary Lineker for having the temerity to speak his mind. The Scottish Government has recently published a paper setting out an alternative to this ineffective and failing system. In Scotland, ending the hostile environment and ensuring humane, fair and compassionate refugee and asylum policies would be a priority. We should never forget the traumas, the unimaginable suffering that leads people to flee their homes. They are people just like us, Were it happening to us, we would all hope to be treated far better than those in the government benches would have it, to find safety and sanctuary when we needed it the most. It was on this principle that the Refugee Convention was created. We should stand up for that principle today and reject this cruel, unworkable and illegal bill.
Yeah. Just to clarify, the reasoned amendment that's been selected is the one in the name of the Leader of the Opposition. I know that the Honourable Lady referred to that to start with. If I have got any chance of getting everybody in, I do need to put a time limit on, which I will do now. It's 8 minutes for the moment, but it will go down, I'm sure. But I have been able to notify the next speaker of that time limit. So William Cash.
Mr. Speaker, in the recent Rwanda case, which is the most recent case on matters relating to parliamentary intentions and the supremacy of law and the rule of law, and the proper application of the rule of law, it is quite clear that one claimant, and it only requires one claimant, because his claim was dismissed by the court on the grounds that parliamentary sovereignty had already undermined his case. The case was about retained EU law, but it actually undermined the case of that claimant. This was a clear indication that the court was going to take the sovereignty of Parliament first, and that is the key issue in front of this debate. It has been said by the courts that sovereignty trumps international law. It is absolutely clear that that is the case. And could I add that the House of Lords Constitution Committee only this year said, Article 58 of their report on the rule of law, etc., said, parliamentary sovereignty means that Parliament can legislate contrary to the UK's obligations under international law. Indeed, that was a reinforcement of the cases I've already mentioned in an intervention, including that of Lord Hoffman, as well as Lord Bingham, Lord Denning. Our greatest jurists have all come to exactly the same conclusion, including the president of the current court, which dealt with the Rwanda case, where he said the same thing in paragraph 144 of their report, in which he says, the principle of legality does not permit a court to disregard an unambiguous expression of Parliament's intention, such as that with which we are concerned. So the position is completely clear, and those cases, if I may say, before the Honourable Lady seeks to intervene, I want to get this quite clear. The Miller case was on a different set of circumstances, and not only that, it's actually been overtaken by subsequent constitutional judgments by the Supreme Court itself. So I just want to quote now from Lord I will give way. She can say what she likes.
It's refreshing to know that my Article 10 rights haven't been withdrawn yet. But the point is this: he may be right as a matter of the domestic law of England that the sovereignty of Parliament. He may be right. It's in dispute, as we know. He may be right that the sovereignty of the English Parliament allows England to change its domestic law internally. He may be right. What he is definitely not right about is this Parliament cannot domestically legislate to take us out of our international legal obligations without doing so clearly. The Supreme Court have been crystal clear about that. There's two separate matters here. There's the domestic law and then there's international law. If the government wants to breach its international legal obligations, then am I not right, based on Supreme Court authority, that they will actually have to withdraw from the treaties to which they're committed?
I absolutely am glad that she mentioned the fact that an unambiguous statement, an explicit statement, as Lord Sumption puts it, as to what the position is in interpreting the intentions of Parliament does carry enormous weight and in fact overrides international law obligations. I'm going to read out from Lord I will not give way. I will not give way. I'm going to quote directly from Lord Hoffman himself in relation to an ECHR case itself. He says the This is the case of R versus Lyons, 2003. The convention, he says, is an international treaty, and the ECHR is an international court with jurisdiction under international law to interpret and apply it. But the question is a matter of English law, and it is firmly established that international treaties do not form part of English law, and the English courts have no jurisdiction to interpret or apply them. Parliament may pass a law which mirrors the terms of the treaty and in that sense incorporates the treaty into English law. But even then, the metaphor incorporation may be misleading. It is not the treaty, but the statute which forms part of English law. And English laws will not, unless the statute expressly provides, be bound to give effect to the interpretations of the treaty by an international court, even though the United Kingdom is bound by international law to do so. Of course, there is a presumption, a strong presumption, in favour of interpreting English law in a way which doesn't place the United Kingdom in breach of international law. But, and this is what he says, this is absolutely crucial here, but the sovereign legislator in the United Kingdom is Parliament. If Parliament has plainly laid down the law, it is the duty of the courts to apply it, whether that would involve the Crown in breach of an international treaty or not. That is what the law is. And that is a straightforward interpretation and statement of what has been said. Now, there is an issue which I want to come on to, because my honourable friend, who I praise for his courage, actually, and also for a brilliant speech, I would simply say, I would endorse every word he said. I also would just simply like to say this. We want the government to succeed in its legislation, but it has to be legislation that works. And as I've explained, in relation to the Supreme Court, the whole question turns on the intention of Parliament and the sovereignty of Parliament. It's a question of justiciability as well. If there are to be amendments, and I put this to my right honourable friend at the moment, I'm sure he'll be right honourable very soon. The fact is that when it comes to it, in this bill, we can make changes. It is possible to extend the scope of the bill, and it is possible, and I hope he will have discussions with the Clerk of Public Bills, who I've had discussions with already. The point is this, that it is absolutely clear that the scope of the bill will determine amendments, whether they're from the government or from backbenchers. And it does matter that we're entitled to have a proper debate about this fundamental question about international law and its relationship to sovereignty. Only one case taken to the courts on this bill, if enacted after royal assent, could be scuppered by a claimant and by the courts if the words of the Act were not clear, express and explicit in ruling out any such claim, for example, under Clause 4 or any other heading such as Rule 39 and all these other things which we will trot out, no doubt, when it comes to committee stage, if we get there. What I can say, however, is that you have to address the question of the scope of the bill, because that's the way Parliament functions. That is the way the Speaker has to decide about the selection of amendments. So this is crucially important. I would also just like to conclude by saying, because I've got much more I could say, but I want to just draw attention to this global issue. The fact is that in the whole of the European Union, there is a real problem. They are tearing their hair out because they have got the Charter of Fundamental Rights on the one hand, and they are bound by qualified majority voting to comply with a situation which is actually not the same as us, because we have a unique opportunity in our parliamentary system with the sovereignty of Parliament to be able to make amendments and to provide domestic law that will satisfy the voters of this country.
Chair of the Home Affairs Select Committee, Dame Diana Johnson.
Deputy Speaker, and can I first start by expressing my condolences on the news of the death of an asylum seeker on the Bibi Stockholm barge this morning. It's now almost 1 year since the Prime Minister pledged to stop the boats. No one here is arguing against that goal. We all want to see an end to people risking their lives by getting in small boats and crossing the Channel. However, the Home Affairs Select Committee stated very clearly in our report on Channel crossings last year that there was no silver bullet to end small boat crossings. We said it would take a variety of policies to be adopted, including safe and legal routes, additional cross-border policing to go after the criminal gangs, and many more recommendations. We even suggested the innovative idea of piloting asylum claims being piloted in reception centres in France in a similar way to the juxtaposed border controls that we already have with France. In April 2022, the then Home Secretary, the Right Honourable Member for Whittam, announced the Rwanda scheme, and since then an extraordinary amount of financial and political capital has been poured into this policy. Whilst we accept progress has been made on some of the recommendations that we made in committee, including clearing the legacy backlog and developing work with France and Belgium, the eyes of the government have been locked on the Rwanda policy and its implementation. However, the underlying assumption of this policy is that the prospect of being sent to Rwanda will act as a deterrent for those thinking of crossing the channel. Let's not forget that the Rwanda policy required a ministerial direction to the Permanent Secretary to get the scheme underway. Why? Because the Permanent Secretary wasn't convinced the scheme constituted value for money. In this case, there was and remains no clear evidence base that the deterrent effect would actually work, casting doubt on the scheme's value for money. Likewise, the Home Affairs Committee was concerned that the policy was good at generating headlines, but lacked a clear evidence base and full costings. And the Home Affairs Committee has been attempting to scrutinise the policy ever since. What has been really striking about this is, though, how difficult it has been to get facts and information from the Home Office on the details of the Rwanda scheme. And this has undermined the committee's ability to perform our scrutiny function. For example, we know that an initial £120 million has been paid at the start of the agreement, and that there would be a payment for each individual sent to Rwanda on top to process their claim, and for successful claimants to receive up to 5 years of support from the United Kingdom. We've subsequently learned that a further £20 million has been paid as a down payment on the initial costs for processing asylum seekers. So we know a total of £140 million had been paid. We'd repeatedly sought information, but were always met with claims of commercial confidentiality whenever we asked those questions about additional funding. So it was with some surprise, therefore, that I and the Honourable Member for Hackney South and Shoreditch received a letter from the Home Office Permanent Secretary last Thursday evening informing us that an additional £100 million had already been paid to the Rwandan government in April 2023, and a further £50 million will be sent in 2024. Just want to turn to the issue of the payment for each person that will be sent to Rwanda. At the Home Affairs Select Committee on the 29th of November, we couldn't bottom out with the Permanent Secretary what the actual cost per person of being sent to Rwanda would be either. The impact assessment to the illegal migration bill had estimated £169,000 per person, but the Home Office officials couldn't actually confirm that in November. So in asking Parliament to support this bill today, it is essential that we know the costings, whether this is actually value for money, and whether it will actually work. Parliament is being asked to assess whether the bill before us today will deliver a scheme that is an appropriate use of public money, without the government actually telling us exactly how much public money is due to be spent. So I hope the Minister will be able to confirm today exactly how much money has been spent, has been pledged, and budgeted for each year of the UK-Rwanda memorandum and now the treaty, and that he will commit to providing quarterly financial updates to Parliament. And I want to turn to the specific provisions in the bill. Under this bill, we all know the aim will be for irregular migrants arriving in the UK to quickly be sent to Rwanda, with very few legal opportunities for appeal, and with Clause 3 expressly disapplying several parts of the Human Rights Act. The Home Affairs Committee noted in our report last year that the government risks undermining its own ambitions and the UK's international standing if it cannot demonstrate that proposed policies such as the Rwanda Partnership, now being legally challenged at that time, are compatible with international law and conventions. As we know, Clause 2 of this bill would require all decision makers to accept Rwanda as a safe country for removals, despite the ruling of the Supreme Court. As a very distinguished former Solicitor General, Sir Edward Garnier KC, has said, it's rather like a bill that has decided that all dogs are cats. Indeed, the bill does not resolve any of the issues raised by the Supreme Court. The Supreme Court decision was based on evidence that Rwanda had previously violated international human rights treaties. This bill is not a magic wand that suddenly makes that evidence disappear. And I would question, why is the need to legislate that Rwanda is a safe country in this bill? If the treaty says Rwanda is safe, shouldn't the government be confident that the courts will now come to a different view and conclude themselves that it is safe? The bill will prevent the courts carrying out independent and rigorous scrutiny of any claim that there are substantial grounds for fearing a real risk of refoulement or treatment contrary to Article 3 of the European Court of Human Rights. However, I understand that this would be incompatible with the UK's international obligations under the Refugee Convention and ECHR. So is the Minister concerned about the impact of the bill on the UK's international standing, particularly given the absence of an evidence base for its deterrent approach? And is the Minister also concerned by effectively reversing by statute a Supreme Court judgment on the facts that this bill could undermine the constitutional role of the judiciary? Just turning now to some very practical questions. Within the treaty, it talks about the seconded independent experts who will be supporting asylum decision-making for the first 6 months. It talks about asylum appeals made by a new appeal body. It also talks about free legal advice and representation from legal professional members of the Rwandan Bar Association. All of these things will take time to develop and will need investment. And I wondered whether there is an additional cost there that the Minister might like to tell us about. I have no doubt that the Rwandan government have entered into this treaty in good faith, but whether this treaty has been entered into in good faith or not by both parties is beside the point. What matters is whether Rwandan officials will recognise and comply with their obligations and whether there are sufficient resources and adequate capacity on the group to enable this, neither of which can be guaranteed by the treaty or this bill. So I hope that the Minister will provide that evidence today, that capacity building and attitude change has taken place, therefore addressing the Supreme Court's concerns. The challenge of stopping dangerous small boat crossings is real, but so is the challenge of clearing the backlog, ending the use of expensive hotels and delivering an asylum system that works. They all warrant serious evidence-based solutions with full costings.
Cox.
Speaker, in defending this bill, which I will attempt, one has to reckon with those who think that it goes too far or may go too far, and those who think it goes not far enough. So let me, Madam Deputy Speaker, first address those who think it goes too far, of which the Honourable Lady who has just spoken is an example. This bill is criticised on the basis that it deems Rwanda to be safe. It is said that is an illegitimate legal technique. It is said it perpetuates or perpetrates a fiction in law. That is precisely the same fiction which the Labour government adopted in 2004 in the Immigration Treatment of Claimants Act, 2004. Yes, it is. It was changed 2 or 3 years later, but in a case before the Appellate Committee of the House of Lords, Naseri, their lordships upheld as a matter of law the deeming of countries to be safe and within the law. And indeed, they went on to say, Lord Hoffman, I think, being one of them, that while Parliament deemed it such, there was plainly risks if the Home Office did not keep an eye on the state and conditions in the nations and the countries that were thus deemed, but otherwise it complied with the law and the courts would respect Parliament's decision. Now, what is said in this case is that, but there is a Supreme Court decision which has already held Rwanda not to be a country for the to be safe for the purposes of the guarantee against refoulement. And it is said that for this House to overrule the decision of the Supreme Court in such an individual case is constitutionally undesirable and contrary to fundamental constitutional principle. Mr. Deputy Speaker, I do not agree with that analysis. First, it is open to this Parliament at any point to take steps to reverse the effect of a judicial ruling. That is the consequence of parliamentary supremacy. It is clear that Parliament should be restrained in doing so in cases, for example, where individual rights, in an individual case, to reverse a determination which has been made in favour of an individual plainly would be contrary to fundamental constitutional principle. But that is not what we are doing here. We are seeking to do precisely what the Labour government did in 2004 by saying that Parliament, legitimately weighing the evidence, has concluded that Rwanda will not engage in the refoulement of those sent to it. That is something that the courts have already accepted. It is something that it is open to this House to do, and it is something, in my judgment, which is perfectly legitimate for Parliament to undertake. It would be different if it was to reverse a decision against an individual. But even if I am wrong about that, even if, as a matter of constitutional convention, it were undesirable for this House to reverse the effect on a question of principle, namely whether Rwanda is safe for the purposes of refoulement, the facts have changed. There is now a binding treaty, which is not only binding in international law, but is binding in domestic Rwandan law. Because Rwanda has a system, my right honourable friend, the member for Stone, has rightly analysed the situation of international law. In this country, we have a dualist jurisdiction where treaties are not self-executing. But in Rwanda, the treaty is self-executing. So the treaty will be binding not only as a matter of international law on the Rwandan government, but on the Rwandan government as a matter of its own law. And that treaty contains a range of important safeguards, including as a long stop the fact that no individual removed to Rwanda from this country can be removed to a third country without the consent of the United Kingdom. If that long stop is in place, if it is binding in Rwanda law, if it is binding as it is in international law, I would suggest there is simply no credible risk, if treaties and legal rules mean anything in the countries, both in the United Kingdom and in Rwanda, of refoulement. Exactly right. If the risk of refoulement has been removed, then there is nothing inappropriate with this House determining, as the Labour government did in 2004, that this country, Rwanda, for the purposes of refoulement, is safe. So I say to the House, it is appropriate, it is a judgment that we can make as the House to take the step that we are now doing. Now let me move to the third question, because the third question to me about, I can't give way, I don't have time. The third question is the most important. The exclusion of access to courts. This bill carefully preserves the right of individuals to come to court in extreme cases of individual justice. I would submit to those who think this bill goes far enough, and I listened impressed by my right honourable friend, the member for Newark, that we cannot sacrifice the principle of access to a court. If we eliminate it entirely, not only would this bill collapse, because it will be interminably impeded in the House of Lords, it will probably lead to the Rwandan government withdrawing, and it is conceivable that the courts themselves may entertain for the first time a complex challenge about the right of this Parliament to do away with fundamental constitutional principles such as access to a court. This House and its supremacy does not necessarily mean that it does not operate within a complex system of constitutional institutions. each of which it has its own place as a component part in that system. No, I cannot give way. I simply do not have time. I simply do not have time. Constitutional principles compete in creative tension. Parliamentary sovereignty is the most important of them, but there are others that are fundamental, and one of them is access to a court in extreme cases. That is what this bill preserves. And I say to my right honourable friends, I understand the frustration and the deep and intense dissatisfaction with the current situation. I share it. I think there are tightenings that we can do, particularly on Rule 39. But on the preservation of the right to go to court in an extreme case, I say that is part of the British Constitution that our fathers and our party has supported and fought for generations. And it would be wrong for us to compromise with it.
Order. I'm sorry to have to interrupt. Order. I'm sorry to have to interrupt the honourable gentleman, but he is fully aware we have to stick to the time limits. After Sir George Howarth, order, who I'm going to call next. I'm afraid, given the number of honourable members that wish to participate in this debate, we'd have to reduce the time limit to 6 minutes. George Howarth.
Thank you, Mr. Deputy Speaker. The government's failure to arrive at a workable solution to the problem of asylum seekers is not just about how they have tried to deal with refugees, as many have already demonstrated, but its failure to create the capacity in our country to maintain reliable services to such an extent that many British people find themselves unable to gain access to basic needs and services to which they are entitled, and also about the stewardship of the economy. Additionally, it's rooted in the government's careless conduct of our relationships with other countries, particularly in Europe. So crucially, in dealing with this sensitive issue, it is, in my view, important to be clear about the principles any approach should be based on. The problem is, however, that the government too often confuses slogans with policy, and in doing so, it fails to take account of the principles on which a realistic policy should be based. Its cynical obsession with creating dividing lines is a barrier to building the sort of consensus my right honourable friend, the member for Normanton, Pontefract and Castleford, referred to. Now, let me, for the purpose of clarity, say at the outset that our country's capacity to admit migrants is finite. It follows that we need a much more structured method of determining how many people can be accommodated, which takes into account the capacity of our public services and our economy. I'll later say a few words about the space that exists in our economy to fill the gaps that we find in various industries and sectors. But one of the principles would be to match would-be immigrants with sectors in which there are not sufficient people to be able to plug those gaps. And many do have those skills. Yeah.
Very grateful to you for giving way. And very briefly, would you agree with me, when we're talking about people who are claiming asylum in the United Kingdom, it would make eminent sense to ensure that they have the right to work whilst they're waiting for a decision, not least because it would allow them to be integrated better into our community when they do get a decision, but also it would reduce the cost to the taxpayer and allow those people to support themselves whilst they're here.
Well, gentleman, for the point he makes, and later in my speech I'll address that very point, if I have enough time. So now perhaps I can say a word about the capacity of those services. In England, the NHS waiting list for hospital treatment rose to a record of nearly 7.8 million in September, up from approximately 2.3 million over the past 2 years. Ambulance response times have also risen, with the average response to a call of going up to 1 hour 30 minutes in December, 2022, which compares to the target of 18 minutes. Or take housing. The UK is experiencing an acute housing crisis, with house building consistently failing to keep pace with demand. The National Federation of Housing Associations say that there are 8.5 million people in England who are in housing need, 42 million of which are in need of a social rented home in England. And in England in 2022, people were having to spend over 8 times their annual salary to purchase a home. In terms of school capacities, in 2020-21, 17% of primary schools were at overcapacity, and in secondary schools the figure was 23%. Mr. Deputy Speaker, we didn't get to this position by accident. It's the result of 13 years of careless neglect and the obsessive pursuit of shrinking the state. Now I'll turn to the capacity of our economy and the ongoing skills shortages we're faced with. GDP is at zero growth, and low GDP growth is forecast to continue into 2024 and possibly beyond. The Office of Budget Responsibility's latest economic and fiscal outlook stated that living standards are forecast to be 3.5% lower by 2024-25 than at pre-pandemic levels, which is the largest reduction in real living standards since records began in the 1950s. The skill shortages I've referred to do not only affect our overall economic performance, they are having a negative effect on our provision of public services such as health, housing, and important sectors such as food supply and the care and hospitality sectors. As I've already said, many of the refugees here already do have those skills, and with a constructive approach from the government, would be able to plug the gaps in those sectors and consequently help grow the economy. Before I conclude, Mr. Deputy Speaker, I'll say a few words about how our poor relationship with Europe and the wider world makes it more difficult for us to cooperate with other countries, whether bilaterally or through collective international efforts, to deal with the deeply damaging consequences of war and conflict, part of which is the growing displacement of people from their homeland, which results in mass migration. Bluntly, we are not trusted as a reliable and constructive partner, and our international influence is diminished to the extent that other countries simply don't take us seriously. As I said at the outset, the government has tried to turn a slogan, "Stop the boats," into a policy, and consequently has failed to offer a solution to this problem. Many on the benches opposite know that this is the case, but are splintered into factions, either wanting to go further, as we've already heard, or regardless of our international obligations, or they're aware that another, more effective approach is needed. Sadly, this bill and their conduct illustrate that the Conservative Party is not a competent or coherent party fit to govern, but rather one riven by warring factions. Frankly, it's now time for them to make way for a national leadership and party which will deal with our mounting problems calmly and competently.
After a good deal of hesitation, I shall support this bill tonight, but it's a hesitation that has been real, because for me it goes as close to the wind as one can constitutionally do. I listened with great care to the very eloquent speech by my right honourable and learned friend, the member for West Torridge, Torridge of West Devon. I agree entirely with his very careful analysis of the bill. I'd say just this too. It is a novel and unusual approach. We are dealing with an unusual and pressing situation, and therefore I think straining the sinews of what is acceptable can just be justified. But equally, the idea that legislation is the sole or even the principal solution to this is, I think, wrong. Ultimately, what is required is an operational solution. And what is surprising is that some previous occupants of the Home Office did not think about that rather more. I know others did, and it's a pity that they were not acted upon more. But ultimately, it will be operational measures that make the real difference. If this can make a difference, and provided there remain the safeguards that my right honourable learned friend has referred to, I can, with hesitation, live with it. I'm indebted to the analysis provided by the Society of Conservative Lawyers in a paper, and I declare my interest as chair of their executive committee, a paper written by Lord Mansfield, King's Counsel, and Harry Gillow, both experienced in international law. If you want opinions in these things, it's best to go to people with experience in the international law field rather than other fields. They conclude, as I do, that although there are areas which certainly need to be examined with care, the bill falls upon the right side of the line. Deeming provisions are not unprecedented, as has been put out, so has already been set out. I am concerned, and I hope the Minister will take on board and explore as we go forward the particular situation raised by my right honourable and learned friend, the member for Kenilworth, about how deeming provisions interact with international law obligations. Because you can deem in domestic law, but you can't legislate to oust your international law obligations. That said, I think there is force, and I refer to the very useful analysis in the Society of Conservative Lawyers pamphlet, that in reality, if the UK were to breach international law conventions, not only would that be constitutionally wrong, it would also collapse the scheme. Because Rwanda has made it clear that it would not be party to the scheme, and I don't buy for 1 second the rather patronising attitude that says the Rwandans have been put up to say that. I think they're utterly genuine in their belief. And it's also important to remember that there are other countries subject to the jurisdiction of the European Convention on Human Rights who are reported as potentially exploring arrangements with Rwanda. If Rwanda were to be party to a scheme in which the United Kingdom broke international law, Rwanda would inevitably forfeit any opportunity it had to engage with other ECHR countries, and they certainly would withdraw. So people have to be careful what they wish for. If they go too far, they will actually drive the Rwandans out of the scheme and will collapse the whole policy. First point. The other point that I think is important is to bear in mind it's absolutely critical that individual rights of challenge are preserved, as my right honourable and learned friend has said. I'm a Conservative because I'm a constitutionalist. And I'm a constitutionalist because I believe in the checks and balances. And frankly, the day the Conservative Party thinks that ends justify the means and ignore principles of comity and think that any one single policy objective overrides the importance of the checks and balances of our Constitution, it ceased to be a Conservative Party in the sense that most people would recognise it. Maintaining that balance is essential. I think ministers have, with great endeavour, managed just to do that. But it doesn't mean that I don't like much of the wording of the bill. When I look, Mr Deputy Speaker, at, for example, some parts of Clause 1, I look in particular at Clause 1.4, it's recognised that Parliament of the United Kingdom is sovereign and the validity of an Act of Parliament is unaffected by international law. That's a GCSE law statement of the blindingly obvious, if I might respectfully say so. It might best be described as otiose and nugatory. It adds nothing to the bill. It's performative. Well, whichever way round one likes. Pointless might be another way of putting at it. So I wonder what that adds. There's another passage in relation, I think it's Clause 2, subsection 5, in relation to the rule, the approach to interim measures under Rule 35 of the Strasbourg Court's rules. It says that it's for ministers to decide. But again, that states exactly what is the position in law anyway. You've only got to look at the textbook to say, as I did in my intervention, that it's for the governments that decide on Rule 35 issues, because They're directed to the governments, not to the courts. A bit patronising to tell the courts what is well within their competence to know and decide upon. So, with those sort of reservations, I will support the bill tonight. But I just say this. If it were to change and any of the safeguards that have been left in to be removed, then my support would go. Because some people would then have pushed it over the line into the unacceptable and, in my judgment, the under-conservative, and then I would not support it. I don't believe that's the government intention, so I'll help them to get the bill through tonight. But they must be wary of some who do not have the best of objectives towards the government's policy, who might take it in the wrong direction. Let's not get there.
Thank you, Mr Deputy Speaker. It's a delight to follow the honourable gentleman who made one of the best speeches so far today against the bill. Unfortunately, he doesn't follow through with his logic, but I'm sure that by the end of this process he will follow through with his logic, because this bill, he knows perfectly well, is not really acceptable. And in his heart of heart, he would like to vote against it tonight, I'm sure. There are 5 reasons to vote against this bill. First of all, it won't work. The idea that someone who is not deterred by a dangerous journey in a dinghy across the most crowded sea lane in the world will be deterred by this flimsy piece of nonsense is just laughable. Second, it will lead to protracted and expensive chaos because it sails, as he says, so close to the wind legally that it will inevitably lead to legal challenges. And ironically enough, since the ouster clauses mean challenges cannot be adjudicated in the British courts, they will go to the European Court of Human Rights. So the government is actually replacing a UK court with a European court and simultaneously declaring on the face of the bill that it is not satisfied that the bill will withstand a legal challenge based on compatibility with the European Convention on Human Rights. That is a recipe for chaos and for expense. Thirdly, the bill seeks to reverse, by statute law, a finding of fact by the highest court in the land, the Supreme Court. It therefore creates a legal fiction. Its title, The Safety of Rwanda Asylum and Immigration Bill, gives the game away. According to the bill, Rwanda is safe, even if it isn't safe, simply because the government, through the bill, says it's safe. But declaring somewhere safe doesn't make it, of itself, safe. You can no more change reality by law or legal dictate than you can by mere imagination. As Bolingbroke says in Richard II, you cannot cloy the hungry edge of appetite by bare imagination of a feast. And you cannot make Rwanda safe just by saying it. So Clause 2's declaration that every decision-maker must conclusively treat the Republic of Rwanda as a safe country is utterly fatuous. If Rwanda is, either now or in the future, in fact safe, the provision deeming it safe is, or will at that point, be OTOs or redundant. But if Rwanda is not now or in the future safe, that provision is self-evidently wrong in fact and therefore wrong in principle. So Clause 2 is either unnecessary or wrong, or both simultaneously. Fourthly, the bill establishes in UK law a completely new doctrine of the separation of powers, as the ouster clauses, which prevent judges and tribunals from supervising the conduct of ministers in operating the policy they have laid out in statute, put ministers above the law. It is not the sovereignty of Parliament that the bill asserts, it's the sovereignty of ministers. But fundamental to the rule of law is the idea that the Crown, or its modern proxy, the Executive, cannot act arbitrarily, even if it uses its majority in Parliament to declare that it can. That would be the worst form of Henry VIII Act, equivalent to Henry VIII's proclamation by the Crown Act 1539, which deemed that all the King's proclamations, even though they were not approved by Parliament, and I quote, shall be observed as though they were made by an Act of Parliament. Fifthly, now is not the time to undermine human rights and a rules-based order. The UK relies on foreign courts and tribunals being effective. We watch events in Ukraine and declare that the butchery in Bucha or in Mariupol is a war crime. Who do we want to adjudicate that? An international court. We rightly lecture China about human rights abuses in Xinjiang province and about abiding by the United Nations Convention on the Law of the Sea. We invoke Magnitsky sanctions against human rights abusers around the world. But how can we expect others to abide by the rule of law and their human rights and other treaty obligations if we abandon them? The member for Torridge and West Devon was right about one thing. He was wrong, incidentally, about 2004, because what we didn't do at that time was put in an ouster clause, meaning that ministers were free to do what they want. Those who think the bill should go further will get no help from this side of the House, in any of the parties on this side of the House, when it comes to committee and report stage. And as we've just heard, if the member for Stone's demands were to be met in amendments at committee and report stage, Rwanda would withdraw, and the member who's just spoken would withdraw his support for the bill. I don't know why anyone would vote for this bill, but voting for it, despite knowing that it's legally offensive, or believing that it is fatally flawed, in the desperate hope that the government will help you amend it, is just delaying the inevitable. Because the most extraordinary irony of all is that the Prime Minister has had to rely on the Rwandan government to tell him and his MPs that Rwanda won't accept any law that breaches international law. Rwanda, which is theoretically, nominally democratic, but is in effect and in actuality an authoritarian one-party state. That's who's keeping us on the straight and narrow legally. Just think about that before you vote for this nonsense.
It's a pleasure to follow the honourable gentleman, and I was very pleased to hear his strong invocation of the fallacy that we live in a separation of powers constitution. We do not. We live in a constitution of checks and balances. We are proud to have an independent judiciary, an independent legal profession underpinning the rule of law, which we are all equal and subject to. We also have a parliament that is supreme. The crown in parliament is in fact the phrase, which is why, like my honourable friend, the member for Bromley and Chislehurst, I take issue with some of the wording in clause 1, but that's by the way. But the principle of comity, Mr Deputy Speaker, is one that we can ill afford to overlook. What do I mean by that? Well, I mean that mutual respect that has to exist between the different arms of the Constitution. This place is sovereign. We derive our sovereignty from the people. But we also have a responsibility to use that in a responsible way. And this is not a new challenge, Mr Deputy Speaker. Previous generations have faced similar dilemmas, because I am not going to stand here and minimise the emergency that we face from illegal migration, or minimise the challenge that the entire West faces from the mass migration of people who might seek a better life, who are either fleeing war-torn countries or coming for economic reasons. It's an unprecedented challenge for all Western democracies. But challenges like that have been faced in the past. When we were at war, we had to make very difficult decisions in this Parliament to make sure that we struck the right constitutional balance between defending these islands against dictatorship, but not in a way that defended us and protected us out of our very freedoms. Our very liberty itself is at stake. And the way in which we legislate has to be responsible and has to be in line with that respect for our fundamental freedoms. And as my right honourable and learned friend, the member for Torridge and West Devon, said, there is a fundamental truth here that we cannot avoid. And that is, if this bill is amended to create an utter, complete ouster from any individual-based challenge, then that goes beyond the parameters of reasonableness and into the sort of legislation that inevitably sets up a fist fight, not with international courts, Mr Deputy Speaker, but with our very own courts themselves. And I'll give way to my honourable friend.
Of course, my right honourable friend is more than aware of the Privacy International case, and he knows as well as I do that in fact in that case there was a dissenting judgment by both Jonathan Sumption and Lord Reid. I think that sort of sums it up. It was very, very finely balanced on the facts of that particular case.
My honourable friend, contrary perhaps to mythology within the Conservative Party, and I agree on many of these key issues, he and I, for example, would have legislated to overturn the Evans decision, the Prince of Wales letters decision, because we felt that their lordships went too far. But that is an example of this House, potentially this Parliament, legislating to correct a legal decision by the courts. Of course we're entitled to do that, and we should do it where the will of Parliament dictates. But there is a difference, I think, between a scenario like that and the one that we are facing at the moment. Because without more evidence and without more work by the government to blithely create a deeming provision in the face of, let's face it, a very strong Supreme Court decision against the government, would have been to invite disaster. And that's why not only the treaty that has been signed between Rwanda and Britain is crucial, but also the policy statement that has been published by the Home Secretary today, laid in this House, which I urge all honourable and right honourable members to read, because there is no doubt that the facts are evolving and that they are changing, and that we should remind ourselves that the Supreme Court, when it made its decision, looked at the law and the facts as of summer of last year, 18 months ago, when we have moved on considerably. Now, of course, deeming provisions are not constitutionally unprecedented. They're unusual, and that is why the government has to be restrained. But without clause 4 in this bill, I am afraid that what the government will do is to set up a massive glass jaw to be smashed by a court in future, and to invite the sort of constitutional conflict that any good Conservative would not want to see. We don't want our courts being drawn into politics. I have spent my career in this place and my political life arguing against the politicisation of the judiciary, and I've been the first to bring forward legislation to oust the court's jurisdiction. We did so in the Judicial Review Reform Bill and the CART jurisdiction that my right honourable friend finished the job on. Of course, I'm more than happy to be robust about the position of this place and the importance of not having undue and capricious interference with the will of Parliament. I'm the first person to assert the authority of this place. But what I won't do, Mr. Deputy Speaker, what I won't be a party to is legislation that in effect invites the courts to come on up if you're hard enough. That is not the approach that we as responsible Conservatives should take. And to echo the point made by my honourable friend, the member for Bromley and Chislehurst, if this bill is to be amended in a way that crosses that line, then I cannot support that. And I will not support that. And if anything, the government should be thinking very carefully about making sure that this bill is engineered to provide as perfect a balance as possible between its obvious right as a government to get its policy objective through, to reflect the huge concerns of our constituents, but at the same time to work within the parameters of our unwritten constitution. Because I say this is a Conservative government today. What if it was a government of another colour that was doing something that we as Conservatives found mortally offensive? What then would we have to rely upon in the defence of the balance of this constitution? What would be left for us to defend against an overmighty socialist government? Not a lot. And that's why today this has to be, yes, about principle, but we mustn't, at the end of all of this, lose sight of the fact that as Conservatives, it is our constitutional duty to maintain that balance. Remember comity, Mr. Deputy Speaker, and we won't go wrong.
Alistair Carmichael.
Thank you very much, Mr. Deputy Speaker. Can I say sincerely it's a genuine pleasure to follow the Right Honourable and learned gentleman who gave a characteristically thoughtful speech for the second reading and, more interestingly even than that, laid down several markers for future stages should we get to that point. It's a most interesting and unusual second reading debate where you have a debate not just on the bill but played out in front of us the sort of tripartite discussion between that side of the government, that side of the government and the Treasury bench. It is a quite remarkable spectacle to observe, albeit not a particularly seemly one. I was struck by the reliance that the Right Honourable Learned Member for Bromley and Chislehurst placed on the references that the Right Honourable Learned Member for Torwich and West Devon had made to proceedings here in 2004 in relation to the Asylum and Immigration Treatment of Claimants, etc. Bill, later Act. That, of course, as the Right Honourable Leonard Gentleman observed, was where this concept of safe countries was introduced. They listed the safe countries as being all EU countries except Croatia, plus Norway, Iceland, and later Switzerland. It was also another piece of legislation that restricted the access of right to appeal for those whose asylum claims had been unsuccessful. There are perhaps lessons to be learned for us all in how that line of legislation has developed ever since. For me, though, the enduring lesson that I take from it, in fact, is that that bill, not that it was brought in by a Labour government, because it was a Labour government that had David Blunkett as the Home Secretary, but actually it was a bill that was opposed with some controversy at the time by the then Conservative opposition. They described it then, and rightly so, as being clumsy and draconian. I think they were absolutely right about that, and we can see many years later exactly where that sort of legislation has taken us. But what is it, I wonder, about the Conservative Party of 2023 that now finds that sort of legislation to be so attractive? Let's not forget, Mr Deputy Speaker, that what we're dealing with here is the consequence of the refusal of this government to prosecute the case for safe and legal routes. Why is it that we don't find people from Ukraine or Hong Kong trying to cross the channel in small boats? It's because we offer them safe and legal routes. The Rwanda scheme is an unworkable scheme, and we know that because it's never been made to work. The barriers are well rehearsed, but every time they are thwarted, the response of this government is to throw a foot-stamping tantrum. Anyone who ever had any doubt about the depth and scale of Tory self-entitlement can see it laid bare here today. This bill is not about making the system work. It's not about providing an effective deterrent. It is simply about trying to keep a disparate range of forces within their own party together. How many will Rwanda actually take over the 5 years of the agreement? As far as we're concerned, and the only reliable information about this comes from Rwanda themselves, it will be a few hundred. What sort of deterrent effect is that going to have? And everything that we know about this bill, everything we know about the cost of it, actually, comes not from the Home Office, but from the Rwandan government themselves. It is because of the information that they put into the public domain that we learned about the extra £100 million that the government has committed. They were never going to tell us. The problems facing this policy are manifest, and they are not going to be wished away. We should not forget, however, that even were those issues wiped away at a stroke, this bill and this scheme would still represent a moral vacuum where our asylum system should be. It is wrong in the practicalities, but it is also wrong on the principle. It is a liberal value to take personal responsibility to live up to your obligations. Passing on our asylum responsibilities to another country is the opposite of that value. It's a step back from the world. It is a move towards isolationism. It suggests that we have no responsibilities to the wider world. Much like this bill's rewriting of reality to impose a judgment of safety to Rwanda, these plans would reverse decades of the UK leading the way on the international rule of law and rules-based order of which we should be so proud. Many across the House have to ask themselves, having boasted about global Britain, do they now really want to turn us into Fortress Britain? This bill suggests a grim and illiberal mentality that is a far cry from the confidence that our country used to project. And that, Mr Deputy Speaker, is why we should reject it this evening.
Well said. Dame Priti Patel.
Speaker. I have to say, as having been the Home Secretary that negotiated the original Migration and Economic Development Partnership, I find it quite odd to be sitting in this debate today, hearing some of the comments that have been made, in particular people running down the country of Rwanda in the way in which they have been. I just think that is absolutely appalling. And I say that because the partnership with Rwanda was established as a world-leading, innovative way to tackle the challenges caused by mass migration and the displacement of people, Mr Deputy Speaker. It was carefully designed with our friends in the Rwandan government to do one thing that no one in this House has mentioned at all today, which is to raise the international bar when it comes to the treatment of asylum seekers with compassion and support when it comes to their resettlement. And I think it is quite astonishing that so far today, particularly on the part of the benches opposite, while they've been speaking down and talking down the government of Rwanda for the last 20 months, we should actually recognise and welcome the fact that it's a country that already supports and has resettled 130,000 refugees through schemes established with UNHCR and through international conventions. I won't give way, there is no time to give way, and the gentleman knows this. And effectively, these are the types of schemes that we need, the resettlement and working with third countries, to actually deal with this awful, awful, abusive and illegal trade in people smuggling. And it's a stain, I have to say, Mr Deputy Speaker, on this House with some of the awful comments that I've heard thus far about Rwanda and this scheme. We have a moral imperative to raise the bar and effectively look at how we can be better as governments around the world to address these issues. And that is why when I negotiated and agreed the partnership in April 2022, we all knew it would face criticisms and legal challenges, and the government of the day was prepared for this. I said it at the time, and in fact we gave some very clear statements in this House as to the steps that we would take forward. And it was in fact a year ago the High Court found the plans to be lawful. The Court of Appeal ruled against the policy, citing concerns over the issue of refoulement, which are well known. But importantly, as the Supreme Court has since referred to as well, these are issues, and the Supreme Court has emphasised this, that the principles of the policy and the commitment given by the Rwandan government to make the partnership work, they are all fine and they are sound. But there are operational measures, Mr Deputy Speaker, that have to go further, which the government has since outlined through this bill, but actually through statements in this House, which would help to make this viable. Now, we all bear the scars, it's fair to say, and I don't envy the front bench right now. We've all bared the scars, and we heard my right honourable friend, the member for Newark, speak about this, the constant merry-go-round of legal challenges, whether through our own domestic courts or interference elsewhere, and by that I'm referring to Rule 39. I've got experience of dealing with Rule 39. There are organisations, campaigners and lawyers who clearly will do everything possible to frustrate the will of this House and actually the will of a democratically elected government, because that's what we are at the end of the day. We have to rise against these dogmatic beliefs because, quite frankly, there are too many organisations and individuals who are getting in the way and actually effectively letting more claims go to the courts. There are measures that have been passed through this House, including the Nationality and Borders Act, where measures have not been implemented through that Act of Parliament, including the one-stop shop, if I may say so, which actually would save the courts a lot of time and effort by bringing forward the single claims that this House voted through not that long ago, just last year, where repeat claims could not keep on going back to the courts. It's really important, if I may say so, to the front bench and to ministers, that we press upon the government now to go backwards, to go forwards, to bring in these measures that have been passed through Acts of Parliament already. And dare I say it, there may be some in the legislation that's come since. But I would like to ask the Minister, in responding to this debate, how the government is now going to act and prepare for any further challenges through this legislation that may come forward today, actually stands up to the repeat unmeritorious claims that keep coming through the courts, whether it's modern-day slavery. We've heard about far too much. Within Nationality and Borders, we put in clauses and measures to deal with that. We've also seen the summary of legal advice the government has received and read much of the other expert opinion highlighting this. So seeking assurances from ministers on the awareness he and colleagues have on the risks of challenge and how these are going to be mitigated, if I may say so, through the way this bill passes through the House in the conventional way is going to be absolutely crucial. We cannot have more cases bogged down in the courts, and too many of us have worked through that as well. But also, if I may, we have a major problem on detention in this country and the lack of detention capability and size. There are plans with the new plan for immigration to introduce group-style reception centres. I would absolutely press upon the Minister, the Home Office, to work with the Prime Minister and the Treasury now to bring forward these sites, because otherwise we're going to see more Bibi stock homes, more Wethersfield sites, which quite frankly are not the answer to the solution. These Greek-style reception centres will help with the fast-tracking of processing claims and the fast-tracking of removal of individuals that have no right to be in this country. And I would absolutely press the Minister in particular and the Home Secretary to now have an integrated approach so that we can deal with this national issue. The public voted for change. We want to deliver that change for them.
Eagle. Thank you, Mr. Deputy Speaker. Speaking as a lawyer, I must say I found there are still one or two of us left. I must say I found reading this bill I felt quite queasy reading this legislation. It's not the kind of thing that I would expect this Parliament to be considering, and I detected the same level of queasiness in some of the other lawyers who've spoken from the government benches, the former Justice Secretary, the current chair of the Justice Select Committee also apparently found it a queasy experience reading the legislation. I agree with the former Tory law officer Lord Garnier, who used to be in this House, who called this bill political nonsense and legal nonsense. It designates Rwanda as a safe country, but by doing so, it's seeking to reverse a conclusion of the Supreme Court on the facts. Now, it's perfectly reasonable if the Supreme Court strikes down a policy to legislate, but one normally legislates to change a policy, not to try and purport to change the facts or say that the facts which have not changed are other than what the court found them to be. That was the first thing that made me feel queasy. It goes on to try and prohibit any legal challenges that may come forward to argue that Rwanda, having been deemed safe in this way, is in fact unsafe. It says that every decision maker considering this must conclusively treat the Republic of Rwanda as a safe country, notwithstanding any evidence that might come forward to the contrary. And given that the evidence that has already come forward and has been dealt with by the Supreme Court in that judgment led them to say unanimously that it was not safe, it's quite worrying, I think, that we simply seem to think we can legislate to change the facts. It allows a very narrow range of claims, and this comes to the heart of the argument between those on the government benches who wish to beef it up even further to exclude any kind of legal change, and those in perhaps the One Nation side of the Conservative Party that are trying to put a line in the sand to say they won't accept any further amendments. It does allow a very narrow range of claims, but based only on compelling evidence relating specifically to the person's individual circumstances. And even those sorts of claims are excluded in some circumstances, those that relate to refoulement. So excluding courts by Act of Parliament from considering relevant evidence, excluding them from taking account of judgments and laws, including domestic legislation, and fettering their judgment as the bill seeks to do, giving ministers power to ignore injunctions taken together, it's tantamount to undermining the rule of law. It's certainly not respecting the rule of law, as I would expect parliamentarians in this place to do, and as I would expect the government of the day to seek to do if it were to wish to uphold our international reputation. I think it beggars belief that the government's response to its loss in the Supreme Court of its policy is to ask this House to legislate to just declare that it's all fine anyway and let's carry on. And even, as others have pointed out, if we were to start sending asylum seekers to Rwanda as a result of this bill passing into law, it's designed for a few hundred people at most, less than 1% of the people arriving in the UK. And the Permanent Secretary at the Home Office has been very clear when he said there's no evidence it's going to work as a deterrent, whereas most of what we hear from members opposite is that that is the very purpose of the legislation, that it's supposed to be a deterrent. So there we have it. It's actually a shibboleth, a Tory shibboleth. An article of faith it's become for some of the elements of the Tory party, the five families, I think they've called themselves, somewhat menacingly. And as we see this Tory psychodrama unfolding yet again today, in order to try and decide the fate of the latest unelected Tory Prime Minister, to be threatened with defenestration by some of the more right-wing elements of the five families, the country deserves better. And as my right honourable friend from the Labour front bench set out in her excellent speech, time and again they're going for gimmicks and infighting over basic competence and good administration. It's 4 years since the Tories promised to end boat crossings in 6 months. Almost a year after the current PM promised again to stop the boats, 30,000 more people have arrived. Hotel use is going up, not down, as the Home Secretary claimed. It's at 56,000 at the moment, 10,000 more than when the Prime Minister promised to end hotel use. Criminal gangs are not being deterred. Convictions for people smugglers have dropped by 36% since 2010, and the criminal gangs are making far more money now than they ever were. The backlog of undetermined cases remains at 165,000, despite the PM's promise to abolish the backlog of initial asylum claims by the end of this year. It's folly to continue with this farcical failed joke of a policy when what's really needed is competent, good administration. Why not put the money being wasted on this policy into dealing with the actual problem? If the party opposite and the government were to actually try and do that rather more successfully than they've managed in the last 13 years, they might get some credit from this side of the House and from the nation. But there's precious little evidence that there's going to be any of that.
Mr. Deputy Speaker. We all know our constituents want action on this. We all know, if we do surveys and read our emails, that this is one of the most important issues that faces our constituents. But it's not new that the political parties have been debating this. It's not new that the political parties have been making promises on this. The Honourable Lady concluded by bemoaning lack of action and changes in a year and 4 years. When she delved seriously back, she went 14 years. Let's go back a bit further. In 1997, such was the issue of asylum and migration that it merited a mere 2 paragraphs in the Conservative Party General Election Manifesto, and the same in the Labour Party Manifesto. In 2001, my party was saying, with Labour newly in office, the problem here is worse than anywhere else in Europe because of Labour's mismanagement. The government has presided over massive delays in processing applications and admits that thousands of those whose cases are rejected simply disappear. Sorry, this is us on Labour, and never leave. We will ensure, this is us in 2001, we will ensure that those claims are rejected and quickly deported by a new removals agency. Conservatives will restore common sense to Britain's asylum processes. By 2005, Labour are promising a points-based system. We will establish a points-based system, and they're saying we will ensure that only skilled workers are allowed to settle long-term in the UK with English language tests for everyone who wants to stay permanently and end chain migration. By 2010, Labour are telling the country and seeking a mandate for a promise that people need to know that immigration is controlled and the rules are firm and fair. And they're promising an Australian-style points-based system. By 2010, we might, if we listen carefully, hear the echoes from down the corridor from the other place. We are promising we will take steps to take net migration back to the levels of the 1990s, tens of thousands a year, not hundreds of thousands. By 2015, Labour are talking about how broken promises erode trust. And there were echoes in what the Shadow Home Secretary said, where they said they would recruit 1,000 new border staff and they would speed up the process
Mr Deputy Speaker, both political parties have made promises to the British people at election times, and both political parties have then told the British public that it's the other party's fault that it hasn't been addressed. And when we look back, between 1964 and 1997, the UK's net migration figures were never lower than minus 87,000 or higher than plus 58,000. Now it's regarded as a modest year, a low figure, if those figures are in the several hundreds of thousands of net migration. All the time, in the meantime, we see over 8 million people, according to the ONS in this country, who are economically inactive. Mr Deputy Speaker, I will support the government today because I think the government deserve credit for attempting to try and deliver their promises to the British people on the boats. And I think we should unite in this House for once to actually seek to deliver on the promises that we all have successively made to them. And surely if we look at other countries where those promises have been broken, we have seen others, unsavoury, dangerous people who have stepped into that void. And I fear, Mr Deputy Speaker, if we do not once and for all say what we're going to do and do it and deliver for the British people, we could see such a fate ourselves in this country. In my own constituency of Bournemouth West, we have some 4 hotels that are occupied by people who are waiting for their asylum application to be determined. And I'm very clear that that is grossly unfair on them to be trapped in that limbo. And yes, we should do everything we can to accelerate it. But if they have no right to be in this country, then it is fair on the British people, the British taxpayers, and equally fair on them that they get that determination and are returned to the country of origin to get on with their lives. We're seeing far too many people coming in here without the necessary checks, who are then doing things in this country that are deeply unwelcome. And I cite the example of the poor young man, Tom Roberts, who was brutally murdered in my own constituency, who said he was 18 when he came here. He was put into a secondary school. It turned out that he was 14. It turned out that he'd murdered 2 other people in the country before he came here. Mr. Deputy Speaker, we owe it to the British people to be clear and direct. I will support the government. I will support the opposition if they become the government, to find who come here and come here with the right to be here, fulfilling our ancient pledge to offer sanctuary and freedom to those who are persecuted. But we have got to be straight with the British people. If we say we're going to do something, we've got to do it. And we've got to try every means at our disposal to deliver directly for the British people.
Thank
you very much, Mr Deputy Speaker. And I'm glad today's debate has provided some therapy for former immigration ministers to come together and to share a little bit of experience about some of the principles that are at the heart of this bill. I served as Immigration Minister for nearly 2.5 years. In fact, I think I'm the longest serving Immigration Minister still in this House. And so I know a little bit about what it takes to deliver an immigration system, and I have some sympathy with the comments, some of the comments, not many of the comments, but some of the comments that I've heard from the Treasury benches this afternoon. So I just want to say 3 quick things about deterrence, about international agreements, and about staying true to our values in these debates. Mr Deputy Speaker, I was the Minister that introduced the UK Border Agency. I brought UK visas in from the Foreign Office into the Home Office. I brought customs out of Treasury to create a £2 billion agency with a simple principle at its absolute core, that border security in the 21st century cannot simply be about defending the border at the shores of our country. In this day and age, one has to operate a triple border. One has to export the border as far away from these shores as possible. You have to have a strong border at the shores, but then you have got to have strong in-country enforcement. And the only way in which you can get that system to work and to work effectively is to fund it. Yes. And so at a time when global migration pressures have grown so sharply, and the Right Honourable Member for Bournemouth West was right to flag this, there are now 184 million people globally who live outside the borders of their birth. There are now 37 million refugees globally. These migration pressures have been growing exponentially since the fall of the Berlin Wall, and guess what? They're going to grow exponentially in the years to come, not least as the ravages of extreme weather drive more and more people in fragile and conflict and violent countries into poverty. People will always go that extra mile to seek a new life abroad. But if we are to have strong borders for this country, then yes, we've got to have a deterrence. But the deterrence is the speed of justice. It is not the prospect of overriding domestic laws and shipping people off to some remote deportation centre. That is why the Home Office officials are right to say that this bill and the objectives of this bill provide, frankly, very little deterrence. Because what this bill does not do is it does not accelerate the process of rendering a decision on a case, and then if somebody has got no basis to be here, removing them very, very rapidly. We knew, Mr. Deputy Speaker, that we had to transform the speed of deportation under the administration that I ran. That is why we moved heaven and earth to ensure that there was somebody removed with no right to be here at the rate of 1 every 8 minutes. That was the kind of pace that was going to be needed to send a very clear message that if you are found to have no right to be here, then you are going to be removed very, very quickly. That is going to be the most effective form of deterrence. And so the House has got to confront the reality that given a choice of how to spend £400 million of taxpayers' money, do you spend it on building a remote processing centre in a faraway place that your own officials tell you is going to have no deterrent effect whatsoever? Or do you actually invest that money in creating a system that takes decisions quickly and removes people quickly if they've got no right to be here? The second point is that the first thing that you learn as an immigration minister is that you can't remove people unless you've got agreements with other countries to take them. This is not a country that just drops people out of the back of aeroplanes if they've got no right to be here. You've got to get them new travel documents, and you've got to have other countries that agree to take them. And frankly, the most important countries with which we need those kind of agreements are our closest neighbours in Europe. And so can we just confront the reality that if we are about to destroy and wipe out and put into history years, decades worth of human rights agreements with our closest countries, how easy do we really think it is going to be to get return agreements of any type with our closest neighbours in Europe? It is going to get harder and harder and harder because we will be seen not to be good partners, but to be bad partners. And frankly, that will not help us get in place the kind of returns agreements that we're going to need to keep a border and immigration system working well in the 21st century. The final point, Mr. Deputy Speaker, that I wanted to make was a point about the European Human Rights Act. It is a terrible sight to see the party of Churchill now depart so quickly from one of Churchill's proudest legacies. The European Convention on Human Rights was not an idea that was dreamed up out of thin air. The Council of Europe was not an idea dreamed up out of thin air. These were ideas that were led, promulgated, delivered by Winston Churchill. And that vision of a great charter, his vision of a great charter, to bring peace to a war-divided continent was based on our experience of protection against torture, or protection against unfair imprisonment, or protection of life. These are ideas that we pioneered in this country, from the Magna Carta, through to the Bill of Rights, through to the European Convention on Human Rights. And the idea that the party opposite will now lead us departing from that tradition, I think, is a very sorry state of affairs. We, in this country, are the pioneers of human rights. It's an anniversary we celebrated with the United Nations at the weekend. It is something that we should hold dear.
David Jones.
Thank you, Mr. Deputy Speaker. I'm sorry I couldn't hear you in all the excitement. Unusually, the aim of this bill is set out in Clause 1, which is, and I quote, to prevent and deter unlawful migration, and in particular migration by unsafe and illegal routes. Now that is an aim which I'm sure not a single honourable member could disagree with. Illegal migration is possibly one of the greatest scourges of our age. It's evil, it's internationally organised, and it's socially and economically damaging to this country. The Rwanda scheme is an inventive and innovative plan. It establishes an effective, or it's aimed to establish an effective deterrent to prevent illegal migrants, to make them think twice about making that perilous crossing across the Channel. And unfortunately, it has foundered on the rocks of the Supreme Court last month, in which the court held that Rwanda could not be considered a safe country because there were substantial grounds to believe that migrants would face the risk of refoulement or being transferred to their country of origin or another third country. The treaty that the government has concluded does provide reassurance in that regard, and it addresses the problem identified by the court by making specific provision that no relocated individual may be removed from Rwanda otherwise than to the United Kingdom. Now, given the dualist nature of our constitution, the treaty needs to be complemented by domestic legislation, and this bill is that legislation. And it's critical that it should function as the government intends, which is to say to facilitate the removal of illegal migrants to Rwanda without legal impediment. And the question is, does it do so effectively? The bill has been described as the toughest piece of migration legislation ever put forward by a UK government, and there is no doubt that it does toughen the current regime. But it is debatable whether it is sufficiently watertight to amount to a significant deterrent to the boats by facilitating the flights to Rwanda. The bill has been considered by the legal panel of the European Research Group, and I do commend it to honourable members. And the report notes that significant amendments to the bill are required to improve it, but expresses concern that those amendments may well be outside the scope of the bill. One of the most significant problems is that the bill contains no restrictions on legal challenges against removal to Rwanda on any grounds other than that Rwanda is not a safe country. And that clearly reflects the fact that the bill is a direct response to the judgment of the Supreme Court last month. If the bill does successfully block challenges based on arguments that Rwanda is not safe, and the treaty certainly does help in that regard, then it is likely that those advising illegal migrants will focus more on pursuing challenges of another kind. But we should consider Clause 4 of the bill, which specifically provides legal challenges to removal may be made if arguments are put forward that Rwanda is not a safe country for individual migrants based on compelling evidence relating to their personal circumstances. Now, the opportunities for abuse of that provision are obvious. Migrants may well be advised by people smugglers or by unscrupulous lawyers, because there are some, that they should oppose removal to Rwanda on spurious grounds, such as, for example, a non-existent mental health condition, a fear of flying, or whatever. And given that as many as 500 illegal migrants in the height of the summer arrive on these shores every day, 1,200. Well, I stand corrected by someone who knows about it. It's not difficult to envisage a situation where tribunals and courts may be overwhelmed. What I'm saying, Mr. Deputy Speaker, is that I believe that this bill does require amendment. And what I'm inviting my honourable friend, the Minister, to say when he winds up this evening is that the government is open to amendments, and I hear what my honourable friend, the member for Stone, has to say about scope, but that he will also engage with colleagues to see if this bill may be made better. Because at the moment, there are numerous deficiencies that have been identified in the report of the so-called Star Chamber that will, I believe, render this bill inoperable and ineffective. And the last thing we want to do as a House is to expend a lot of time and a lot of agony over putting in place a bill that doesn't result in the flights to Rwanda and the deterrence that we need to illegal migrants. I do hope that my honourable friend will respond positively to this suggestion when he winds up. I know that a lot of colleagues are going to listen very carefully to what he has to say, and I think that they will welcome what may well be regarded as a change of tone on the part of the government.
Thank you, Mr. Deputy Speaker. This bill might be called the Safety of Rwanda Bill, but it's really the Safety of the Future of the Tory Party Bill. It's basically Schrodinger's legislation, all things to all Tories. The ministers might say it doesn't breach international law to make it a dead cat of a bill for some, but it needs to say that it will breach international law to make it work for a dead cat of a Tory party, scrambling to find a reason to provide this. In my contribution, I want to say why I'll be voting against this legislation, to stand up for Britain's proud tradition of human rights, and to urge this place to learn from the mess that was created by the Northern Ireland Protocol Bill, which also repeated these similar challenges. It is extraordinary that the government is presenting us with a piece of legislation that says on its first page it cannot confirm it is compliant with our convention obligations, with the rules of law that we all signed up to support. I think many members on the opposite side have been listening to Oscar Wilde when he said that the study of law was sublime, its practice vulgar. Legislation isn't vulgar, it's imperative to democracy. They should listen more to Winston Churchill, who said the idea of a Charter of Human Rights was for it to be guarded by freedom and sustained by law. But this legislation will not sustain those laws, it will diminish them. We should be proud we were the first nation to ratify the convention that set up the European Court of Human Rights, set up at a time when thousands of people were fleeing persecution, in recognition that the world didn't always get things right. Never remember the children on the Kinder transport who came to this country and their parents that we left behind. It is unimaginable in our own world to manage these issues on our own. That is exactly why we signed up to international treaties, to share the burden, to make a refugee system manageable, to deal with the fact that 60% of people on those boats are being granted asylum because they have a well-founded fear of persecution. And shipping a few of them off to Rwanda, just 5% of those, is at best an expensive distraction and at worst a deception at least. The only thing this piece of legislation will do is make a bad situation worse. Clause 5/3 provides the court cannot take an interim measure into account even if a minister has not blocked it. The bill also breaks our commitment to observe Rule 39 interim measures. In doing that, we breach our obligations under Article 13 of the ECHR, which require member states to provide effective remedies for the infringement of rights in domestic law. In layman's terms, Parliament is being asked to commit the UK to a process breaching our obligations to protect people from torture. No other country has ever tried to challenge Rule 39 jurisdictions. They may not have complied, but this is a completely new departure for us to be leading. And the damage it will do to our status around the world is untold. It will also damage other treaties that we have signed up to. The Trade and Cooperation Agreement states explicitly if we end judicial cooperation, we undermine the agreement. The Good Friday Agreement states explicitly that denying access to domestic courts for individuals on the basis of the ECR contradicts its own commitments. And I'm sure our colleagues from Northern Ireland have recognised that we cannot override legislation in this way. And that means there will be countless legal challenges. We've already heard about the millions of pounds we've spent on a scheme where not a single refugee has been sent to Rwanda for processing. We've already spent £2 million on legal fees fighting this process. That's on top of the extra £150 million we've already pledged to spend on it. No wonder a ministerial direction has been required to uphold this policy. Now, Parliament can pass any law it likes stating things should happen. We can pass laws saying there shouldn't be smoking on the streets of Paris. It doesn't mean that it will happen. And that's the legal fallacy at the heart of this, along with the Permanent Home Secretary saying there is no deterrent effect. I can keep saying I can sing. I could pass legislation to say I could sing. If you came to karaoke with me, you'd realise very quickly otherwise the truth. The cold, hard reality of the law is that this does not change the facts that the Supreme Court identified. And only the people who think it's a deterrent think that they can somehow keep saying to the courts, no, Rwanda's safe, like some kind of Vicky Pollard approach to making legislation. It's time the British public woke up to what this government is doing. You cannot amend yourself out of this challenge without one side of Tweedledum and the other side of Tweedledee arguing anymore. This is a mess. It ruins our standing on an international blowjob. It's more money being wasted. It's more time in this place being wasted when we could go after the traffickers, when we could go after the people exploiting vulnerable people fleeing persecution, when we could speak up for the very values that post-war we stood for in the world about supporting people who are at risk of prosecution. This legislation won't stop the boats, it won't stop the rot, and it won't stop the Tory party tearing itself apart. Britain deserves better, and with this side of the House, it'll get it.
Danny Kruger.
Thank you very much indeed, Mr Deputy Speaker. Let me start by saying how much I support the objectives of the bill, and I pay tribute to the government for the very significant improvements on the status quo that the bill represents. There are, of course, some practical issues which have been well rehearsed on this side of the House with its operations. And as my right honourable friend, Member for Newark, said so well earlier, what really matters is whether it will work. And what working looks like is being able to detain and remove sufficient numbers of migrants quickly enough, illegal migrants, that they decide that the journey across the Channel is not worth it. And that means ensuring that we have the capacity in the system. And I recognise the progress the government has made to improve capacity, but I think, as my right honourable friend says, we have significant concerns about the system getting gummed up with legal claims that are still allowable under the bill. And we're also concerned about the continued operation, potentially, of Rule 39 orders from the Strasbourg court. But, Mr Deputy Speaker, these practical problems, which I think are real and need to be addressed in the further stages of the bill, derive from a fundamental point of principle. And I really do welcome the noises that are made in the bill that would gladden the heart of my honourable friend, Member for Stone. It's rather like build cash bingo in this bill. There's notwithstanding this, and there's supremacy that, and sovereignty the other, and it's all extremely welcome. Nevertheless, these words do not apply in the crucial places. It still rests the right of individual claims on international law, on the case law of the European Court and of the operations of the ECHR in our own country. And let me say quickly, Mr Deputy Speaker, I'm not calling at this stage that we should depart from the ECHR, although I think we could do that. In response to the Honourable Member for Hodge Hill, who just spoke as if we, leaving the ECHR, would be departing from the honourable and ancient British tradition of liberty. Of course, as he implies by his speech, we would be returning to it if we were to leave the ECHR and rest our liberties on the statutes of Parliament and on the common law of our courts. But nevertheless, if the European Court were to disagree with the actions of the government and they issued a substantive ruling to that effect, then we begin a process of conversation with them about that, and we decide how exactly we might comply, or indeed, if we had to, depart. Let me turn, Mr Deputy Speaker, to the Supreme Court judgment from last month, and I think it is pretty important, very important, that we try and analyse the implications of that ruling. It is true, as my honourable friend, Member for Stone, said, that the Supreme Court ruling does acknowledge explicitly that UK law is supreme over international law in one of the cases that it considered. It makes this point in principle. But except in that one case, it doesn't make it in practice. It ruled against the government on grounds that derive from European and international law, as well as other domestic laws. So the court suggested that, in practice, that international law trumped domestic law. And having done that, it then inserted itself into foreign policy. It presumed its right to judge a foreign government. It said it should decide for itself whether the Rwandan government's undertakings could be relied upon. It essentially gave itself special investigatory powers to make judgments of another country. It described, rather patronisingly, the inadequacy of the Rwandan system, as if that's any business of a British court. And while it totally disregarded the UK government, it said the executive of the UK enjoys no constitutional prerogative in this regard. But it did give what it called particular importance to the opinion of a United Nations agency. Yeah. So it asserts itself into foreign policy. It draws down the authority of international law and international global agencies. Where in its understanding is the role of the UK government? Where is its understanding of the role of this place, Parliament, which sets our laws? And I want to just reflect briefly on what the rule of law means, because the phrase is invoked constantly by critics of this bill and of our Rwanda policy, as if international law trumps domestic law. It is not the case that the rule of law implies some kind of hierarchy of law ascending from, parish council, local bylaws, up to the global law. The rule of law means the supremacy of Parliament and the operation of the common law, of case law, made by our courts. And my honourable friend, Member for Stone, cited all the distinguished jurists, Hoffman, Bingham, Denning, not Hale, didn't mention, but did mention Reid, the President of the Supreme Court. International law is, of course, important, and I totally recognise its enormous value in keeping the peace in the world and enabling us to deal with other countries, but it applies to the international plane. And let me touch briefly on human rights law, which has been mentioned as well. There's an assumption that the Human Rights Act has some kind of superior status in our law, and I recognise that is often seen to be the case, but that is problematic. The rights and liberties of individuals, of citizens and of foreign nationals, whether they're legally or illegally here, those rights and liberties are properly protected by statute and case law. And let me finish by saying, Mr Deputy Speaker, I regret we've got an unsatisfactory bill. I can't undertake to support it tonight. I'd hope the government would agree to pull the bill and allow us to work with them and with colleagues across the House to produce a better bill, one that respects parliamentary sovereignty and also satisfies the very legitimate concerns of colleagues about vulnerable individuals. I think we could do better on safe and legal routes, for instance. We should be working together with other countries to design a system that respects the sovereignty of Parliament and the legitimate rule of independent nations.
Thank you very much, Mr Deputy Speaker. This year is the 75th anniversary of the Universal Declaration of Human Rights. What an irony and what a shameful indictment of ministers that our government is marking it by putting in front of Parliament a bill to wave aside our human rights obligations and the judgment of the highest domestic court in this land. This insulting and dangerous legislation attacks both human rights and our democratic structures. In doing so, it both demeans and disrespects the role the UK has played in helping to shape the international rules-based order, including its contribution to the drafting and early ratification of the European Convention on Human Rights in the aftermath of the horrors of World War II. On its very cover, this shameful bill has a statement that the government cannot say it complies with the UK's obligations under the ECHR, a terrible admission of this government's willingness to violate the principle that human rights are universal and belong to all of us by virtue of our humanity. Now, as others have noted, this bill overturns an authoritative, unanimous Supreme Court judgment based on extensive evidence and made just 3 weeks ago. Our highest domestic court ruled that by sending refugees to Rwanda, the UK could breach its obligations under the ECHR and other international laws such as the Refugee Convention, the UN Convention Against Torture, the UN International Covenant on Civil and Political Rights, as well as domestic law. In seeking to oust the jurisdiction of our domestic courts by forbidding them from making assessment of fact and disapplying the Human Rights Act, this bill is constitutionally exceptional and provocative. It explicitly disapplies multiple sections of that landmark act, including basic minimum standards that protect us all, leaving barely any room for judicial scrutiny.